slaves was affected by these trends and decreased. Now, these few facts should make clear that the world the men at the convention looked out at in 1787 was not the world that the nation faced in the 1850s, I should say. These facts should make clear that the trajectory of slavery in 1787 was not the trajectory that led to the entrenching of slavery in the mid-19th century. To understand slavery at the Constitutional Convention, we have to look at it with their eyes, not with eyes enriched or clouded by knowledge of what the future actually held. Now, so as I said, there are these two main ways of looking at our topic, the neo-Lincolnian way and the neo-Garrisonian way. And what I want to do today is to propose a third way, which I'm going to call the neo-Madisonian way, named after James Madison, often said to be the father of the Constitution, or at the very least, the man who understood the Constitution more deeply than anybody else at the time of the founding. Now, I see this Madisonian position as a kind of middle ground between the neo-Garrisonians and the neo-Lincolnians, but it would be wrong to see it as merely splitting the difference. It's different in more ways than that, as I'll try to explain. But the neo-Madisonian view holds that the Constitution is neither pro-slavery, the way the Garrisonians see it, nor quite anti-slavery as the neo-Lincolnians see it. The neo-Madisonian position denies that the Constitution endorses the institution of slavery as legitimate and right, but it also denies that the Constitution made provision to stamp out slavery, or as Lincoln liked to put it, consign the institution to ultimate extinction. Rather, the neo-Madisonian position says three things that I think are more subtle than these. First, it affirms that slavery is legal but not legitimate. Second, it postpones or defers any disposition of the slavery issue to another time and another place. And third, it does so for reasons that are so deep in the fundamental principles of the Constitution as they understood what they were doing, as to make the treatment of slavery in the Constitution nearly inevitable. I want to take up these three themes of neo-Madisonianism in turn, and turn first to the question of legality and legitimacy. Now, it's undeniable that slavery is in some sense legal in the Constitution. It existed within many of the member states in 1787. The Constitution allows the continued importation of slaves for 20 years. It provides for the recapture or something or other, we'll see what it provides for fugitive slaves. But the document is very careful not to endorse this institution that it recognizes as legal. The constitutional clauses that touch on slavery are all written in such a way as to establish unequivocally that slavery is not an institution existing under its authority or with its blessing, but that slavery is an institution of the states. The Fugitive Slave Clause speaks of, quotation here, persons held to service or labor in one state under the laws thereof. Slavery, the Constitution says here, is an institution under the laws of the states, not under its laws. The Slave Trade Clause is remarkably parallel. It speaks of the importation of such persons as any of the existing states shall think proper to admit. The nefarious slave trade is a trade of and by the states engaging in it, not of the union constructed by the Constitution. Moreover, as has been often noted, the words slave, slavery, and any similar term do not appear in the Constitution. In fact, the word slavery does not appear in the Constitution until the 13th Amendment, which ends it. Nor does the Constitution contain any racial references. Instead, the text uses wordy and weird even circumlocutions to refer to the slaves. It speaks of persons held to service or labor, or of such persons as the state shall think proper to admit. If somebody came down from Mars, they really wouldn't know what was being talked about here. Avoidance of these words, slave and slavery and such, this was altogether deliberate. At the convention, it was stated explicitly that such words should not appear in the document, should not appear because they are a blemish in a system seeking to establish and secure liberty. Moreover, when the Constitution refers to the slaves, it refers them invariably as persons. So far as the law of the Constitution is concerned, slaves are persons, not property, only prevented from full recognition and protection of their personhood by the state laws that treat them as property. The Constitution then never recognizes slavery as legitimate, even though it recognizes it as legal under the laws of some of the states. My second point, which I call deferral. Now, in denying slavery legitimacy, the Constitution does recognize it as an imperfection, as a defect in the system. But, and this is a really important point, it makes no provision to do away with it. And indeed, it contains many barriers to national action against slavery. Since slavery is recognized as an institution of the states, the most significant provision in the Constitution regarding slavery is the provision that isn't there. This Constitution, as you, I hope, learned in some course around here, establishes a general government of limited and enumerated powers. None of the powers granted to this government remotely warrants action by the Union against slavery in the states. Slavery within the states is treated solely as a matter for the states themselves to deal with. This matter of course acceptance of the existence, if not the legitimacy, of slavery in the states, I think speaks against the neo-Lincolnian theory. This was not something that was accepted only reluctantly. It was simply taken for granted. Decisive action against slavery, or for it, for that matter, is not provided for in the Constitution. Decisive action is deferred, both in time and place. If such action is to occur, it must occur within the states. Many of the founders hoped, and indeed even some expected, that such action would be forthcoming from the states. The fact was, anti-slavery sentiment was strong, even in many of the states that had many slaves, like Virginia. The fact is that men like Thomas Jefferson and James Madison, both large slaveholders themselves, were cooking up schemes for gradual emancipation within the states. These kinds of facts seem to confirm the possibility that the institution could indeed be eliminated by the states. Thus, at the Constitutional Convention, Connecticut's Roger Sherman noted that, as he says, the abolition of slavery seemed to be going on in the U.S., and the good sense of the several states will probably by degrees complete it. Even some delegates from the deep South joined in with the same idea. Abraham Baldwin of Georgia surmised that his home state, if left to herself, may probably put a stop to the evil. But if slavery was to end in America, it would not be ended by the government established by the Constitution. So the fact of facts about slavery in the Constitution is that it is an institution of the states that have it, and neither established nor legitimated by the Constitution or the government of the Union. However, there are places in the Constitution where the Constitution does indeed make some provision for slavery. There are those 18 clauses that the neo-Garrisonians identified. Are you ready? I'm not going to talk about all 18, I want to assure you. I'm going to limit myself, in fact, to the most famous 3 clauses that the neo-Lincolnians accept and talk about them. The presence of these 3 clauses points to one of the 2 chief points that I wanted to make tonight. And that is that slavery is an institution of the states, but there are some places where it necessarily spills over into the Union. Those are the places touched by our 3 clauses. So I want to look briefly again at those 3 clauses. Of the 3, the Fugitive Slave Clause proved to be the most objectionable in the long run because it imposed on Northerners some involvement with catching fugitive slaves, or at least standing by and watching fugitive slaves be apprehended. Paul Finkelman, who is one of the leading neo-Garrisonians, Paul Finkelman thinks that this clause is particularly revealing of the falsity of the neo-Lincolnian position. Because contrary to the neo-Lincolnians and the way they want to explain things, the Southerners at the Constitutional Convention made no threats to take their marbles or their bat and ball or whatever they had and go home if they did not get this protection. Paul Finkelman, for once in his life, is, as a matter of fact, quite correct about this. And he's also correct to see that this fact spells trouble for the neo-Lincolnian theory. But I'd like to suggest a different interpretation of this clause that doesn't point to the neo-Garrisonian conclusion that he draws. Here's the basic neo-Madisonian idea about this Constitution and ultimately about this clause. So the basic neo-Madisonian idea is this. They were trying to construct a federal union of states with somewhat different domestic orders. Some had slavery, some didn't, some were commercial, some were agricultural, and so on. One purpose of such a union was to have open internal borders which would facilitate commerce and intercourse among the members. Open borders means that there will of necessity be a certain porousness that makes the escape of slaves from slave to free states more possible than it otherwise might be. Now, the Union, in order to be stable, should not be perceived by its members to be subversive of their internal order or to be particularly burdensome to them. One should attempt, in making a constitution for this kind of union, to minimize predictable sources of friction among the members. The open borders and the contiguousness of slave and free states meant that there were likely threats to harmony among the states. Since many of the new free states had become quite hostile to slavery, they might even adopt the very provocative policy of decreeing by law that all persons within their borders were free, because being a state, a sovereign state, means that one has the right to decree the civil status of persons within one's borders. The Fugitive Slave Clause decrees as a matter of friendship or harmony among the states that no state shall have the power to do this. That's why this clause is located in that part of the Constitution that contains other provisions relating to relations among the member states. So, for example, very close to it is the extradition clause. States have a duty not to become a refuge for criminals from other states, but these are to be returned to the states from which they fled. Moreover, the Fugitive Slave Clause contains no provision of power or grant of power to Congress to enforce it. In my opinion, the best reading of this part of the Constitution, as originally intended, is that there is, in fact, no congressional power to enforce the Fugitive Slave Clause. It imposes a duty, the Constitutional Clause imposes a duty on the states to not to attempt to change the legal status of fugitive slaves, and indeed to deliver them up, but it has no mechanism to enforce this other than the good faith of the states. But here is another place where history moved off in a different direction. In 1793, Congress passed a Fugitive Slave Act, which the Supreme Court, wrongly in my opinion, found to be constitutional in the 1842 case called Prigg versus Pennsylvania. Now, if the Fugitive Slave Clause had been left as originally intended, it would have been a much less effective instrument for aiding slavery. But in light of the potentially disruptive results of leaving some of the states free to undermine the domestic institutions of other states, it was easy for the convention to adopt the Fugitive Slave Clause, even without the prompting of threats of disunion. But the clause is not meant as a support for slavery. It is meant as a support for a federal union between states with these different institutions. Now, the Slave Trade Clause was a different matter. This one spilled over from the states to the general government and its constitution because the new government was to be given the power to regulate foreign commerce, which would include the commerce in slaves. The new power given to the Congress would either preempt or trump the power of the states to control the flow of slaves and other things. Now, arming Congress with power over foreign commerce meant that this one aspect of slavery would be in the hands of the general government. It would have to be, just given the fact that they had that power. Now, the neo-Garrisonians concede that here was an area where threats of disunion were made. At the convention, representatives of both South Carolina and Georgia demanded that some provision be made for them to keep the slave trade open, or they would be compelled to stay out of the Union. So General Pinckney of South Carolina insisted, as he said, South Carolina and Georgia cannot do without slaves. Another South Carolinian was even more pointed. South Carolina can never receive this plan for a constitution if it prohibits the slave trade. Now, the neo-Garrisonians believed that this was a bluff, that they would not have stayed out of the Union. And perhaps it was. There were many, many good reasons why Georgia and South Carolina needed to be in the Union. But at this time, there were many worries, rumors, other kinds of worries circulating around the continent that if this effort to make a union, remember this was the second try they had at it, if this effort to make a union failed, the union would dissolve into three separate, smaller unions, a New England Union, a Middle States Union, and then a Southern Union, or partial confederacies, as they would call them. That fear that the Union of the whole would dissolve into these partial confederacies played into the even more fearful prospect that a string of partial confederacies would provide an open invitation to Britain and to other European powers to regain a footing in this part of the continent and to bring with them European balance of power or power competition politics. Now, in the face of these possibilities, it's perhaps understandable why the convention did not wish to see if Georgia and South Carolina were bluffing, and why they agreed then to accept a 20-year extension of the slave trade for those states that wanted it. Finally, turn to the last of the major clauses on slavery in the Constitution, the so-called 3/5 clause for representation and taxation. Now, this is probably the clause that has had more nonsense spoken about it than any other part of the Constitution, and that's going some. The Second Amendment is up there. Now, the usual point is captured in the title of a book, 3/5 of a man, with the point being that counting the slaves as 3/5 was a statement of the Americans' estimate of the degree of humanity of black people. Now, I think there are at least two important facts that speak against this interpretation. First, free blacks were counted as full persons for the purpose of representation, and as I suggested to you, the statistics show that there was a fairly large and growing number of free blacks, so this was not negligible. And so this was not also a racial matter per se. The second fact of significance is that the slave states and the slave owners at the convention were the ones pressing to count the slaves as full persons. And the Northerners, who were in the process